think we're going to go ahead and get started. We're just an hour away from our wonderful reception. I hear some wonderful conversations right now. You can continue that at the reception, but right now I'm just excited that we're on schedule. And I have the extreme honor of introducing our keynote speaker for tonight, Miss Cindy Cohn, no E. Just want to make sure I pronounce that right. Cindy Cohn is a legal director and general counsel of Electronic Frontier Foundation. I will let her own words and the bio in your programs do the speaking for themselves, but I will mention one thing because I know she won't. Just last week, she was named one of the top 100 most influential lawyers in America. So congratulations, and without further ado, Cindy Cohn.
Thank you so much, and thank you for inviting me. This has been really fun for me. I have to admit that these are three topics that EFF has been involved with a little bit, but I personally haven't been as involved. So it was fascinating, all of the panels. I hope you guys appreciate what a great group of people came and spoke with you here today. And thanks to Penn for inviting me. I came out personally because, and I'm going to be really frank about this, I want to have a better connection between Penn Law and EFF. I know you guys have an IP clinic. I'm very excited about that, and a bunch of good professors, including my old intern Shyam. And I would like EFF to have a better connection with Penn. We have it with a lot of the top law schools, and you guys should certainly be one of them. So that's my unapologetic reason for coming here today to talk to you. In thinking about what to say to you guys today, I was trying to pull together some of the strands of the topics today. And the first thing that I really, that we noticed, and we noticed throughout all the panels, is that, none of this is really very new. People have always made up new rules for old games or used game pieces for other things. Card games all have regional rules, as do many others. People have always wanted to take their favorite characters and put them in new settings. When I was a kid, we used to play Star Trek in my neighbor Stacy's tree with the Enterprise on the top and Scotty's Engineering down at the bottom. Or even older, the tradition of the wandering storytellers that we heard about a bit in the fan fiction panel. And if you want a really great take on that history, there's a wonderful novel by Frank Delaney called Ireland that follows a bunch of Irish storytellers around, and you get the flavor of people taking, culture and making it their own and shaping it and changing it as time goes by. People have always tinkered with their physical stuff. 3D printers are amazing, and I haven't even begun to think about all the issues here. I'm far behind Michael in that. But people have always wanted to tinker with their stuff. The idea of the gearhead is certainly as old as there have been cars, and certainly in the little town where I grew up, they made all sorts of crazy contraptions by welding together one piece of this to another piece of that and making things work, and sometimes not work. In ways together. But, Professor Larry Lessig and others have talked about this. Technology often takes small, latent problems in the law, latent issues in the law, and makes them big and real. And what we've seen is that the shift in technology has really resulted in little things like my ability to play Star Trek in my backyard getting turned into something where you can publish something to the entire world, and you can be much more creative and interactive with things than you used to be able to. But before I talk about some of those problems, and we've dug through some of them, again, I kind of want to step back a little bit and talk about, frankly, why the internet is so cool, because I love talking about that. Before we get into the hurly-burly of copyright law and intellectual property law and the tangle that they make with new technologies, I think we've heard a lot today, and I really loved it in every panel, about people talking about how much some of these games, some of these technologies especially, have meant to them personally. We heard a bunch of personal stories here today. It's true that technology has created some struggles for intellectual property law and for intellectual property rights holders, but I don't want that to get lost in the mix of what technology has given all of us, rights holders as well, but not just them. I come to technology as a First Amendment attorney. That's what I am at heart. And the reason that I got interested in the internet was because of the ability for it to allow people to talk to each other at a level far beyond what had come before. And we've seen it as a tool for political organizing, as a mechanism for freedom of speech, as a communications tool. And I think in the context of 3D printing, we're going to be able to see people move beyond words to devices as a measure of speech. Now, the free speech law has long recognized that some speech is things. I think that we're going to begin to see a lot more things as speech as we move forward in that area. And we also know that every new technology, at least most of the ones that we love now, has had to have a battle to get its rights heard. Movies were around for 50 years before they were declared to be a medium of freedom of expression by the courts. So we know that there are going to be these fights, and we know there's going to be these battles. But I think we should start from the position that the technology is cool, it's important, and it's given us a lot of things, and then go from there into how we want intellectual property laws to interact with this thing. But here we are. We're at a legal conference in the midst of ongoing struggles in all three branches of government, on university campuses, and in the public debate. And clearly the introduction of digital computers and networks have caused problem for business models and legal concepts built in an earlier time. If you want to think about where, I think you need to start with the perspective of where certainly copyright law comes from. And I think that one of the things that copyright law is plainly done, and there's a great book. I decided that at the end of the day I was going to give you a lot of pictures, even though they're not really centered to my... there's a great book that is written by a professor at the University of Michigan named Jessica Littman called Digital Copyright. And it's the history of the Digital Millennium Copyright Act that was passed in 1998, but it covers other topics as well. But one of the things that she talks about and does a great job of explaining and in fact proving is that our copyright laws didn't come down from a high temple. And while copyright itself is in the Constitution, the actual mechanisms of how copyright works are completely creatures of statute, and those statutes are written by our Congress, and they're written in a particular context. And the thing that Professor Littman does very well is demonstrate the stakeholderness basis of copyright law, especially the 1998 Digital Millennium Copyright Act. And if you look at who was present and who was around the table, you can learn a lot about the kind of deals that were cut. And I will say that despite some efforts by my organization, which was much smaller then, and other people involving, and librarians and some security researchers and some other folks to get involved, the vast number of stakeholders at the table and the power that was exercised in that table was the power on the behalf of the various content industry lobbies. And that's the resulting law that we have today. So we had a world that was written by a bunch of stakeholders for a bunch of stakeholders. In 1998, that might have made some sense. Copyright law didn't matter to ordinary people nearly as much then, and the laws that they were writing reflect that time. But now, in the words of my friend Clay Shirky, here comes everybody. And suddenly we're all able to use these technologies, manipulate them, and play with them at a level before. But the copyright law hasn't really changed all that much. And it's not just the law itself. There's a huge thickets of contracts and business models built around the exclusive rights in 17 U.S.C. 106, the rights to reproduce, to distribute, to display, or to perform copyrighted works, and most importantly for our friends in the fan fiction world, to make derivative works. Everybody came into copyright law specifically, and I'll talk a little about trademark law as well, into a world that was very well meshed and created by a bunch of people who frankly weren't us, at a time when that didn't really matter very much. And of course, we have a content industry that has a history of wanting to not only control the works themselves, but also to control our means of interacting with them. There were huge patent fights over the film projectors and movie projectors, with the industry claiming the right to control movie projectors because movie projectors projected the content that people had. And of course, very famously, the Betamax case with the movie industry wanting to be able to control the means from which we can record and time shift movies, and in favor of their own, ultimately their own product, something called DiscoVision, which tells you more about the time of the battle than it does about what the device did, as the way that people would interact with home taping. So this is the landscape that I think users wandered into when technology gave them the ability to interact, create, control, or, in the words of the advertising folks at Apple, rip, mix, and burn their own technologies. And I think at bottom, there are really two key tensions that arise out of the development of computers and computer networks. On the one hand, copyright law is based on the proposition that granting a creator or their assignee the exclusive right to control copies as a mechanism for incentivizing the creative works and for the public to enjoy. So copyright law grants a statutory monopoly to creators, and then later to their assignees, in order to try to create an incentive for the creation of copyrighted works for everybody else to enjoy. Trademark law, at its core, does a similar matter, which is it creates control, it creates a kind of monopoly in certain words in commercial contexts for a very different purpose, which is consumer protection. But both of them have the lever of control. And what do computers do? Well, computers copy. They copy not just a little, they copy a lot. They copy all the time for many different reasons, and often in ways that we don't even understand, like caching or things that are not that we don't understand, but that are outside of our control, or most users' control. And what do networks do? Networks make sharing, distributing, displaying things easier than it's ever been before. So these doctrines are, I think, there's a fundamental problem at the bottom of the IP fights that we're living in that these doctrines are based upon the idea that copying is hard, distribution is hard, and display is hard, and making derivative works is hard, and none of that is true anymore, and it never will be again. Technological protection measures be damned. It never will again. And so we end up in a world where there is a fundamental conflict between the way our legal system is set up and the way that our technology works, and frankly, ought to work. Again, I think that both of these are features, not bugs, in our technologies. The Supreme Court recognized over 15 years ago in Reno versus ACLU that the internet is a powerful democratic forum in which anyone can become a pamphleteer or a town crier with a voice that resonates farther than it could in any soapbox. And of course that's true in our world, as we've learned. As last week I was on a video conference with colleagues in England, Brazil, Korea, and Washington, D.C. to talk about international due process principles, and how we all watched the Arab Spring through tweets and video and other things. These copying, and that's the display side. Of course, copying lets us edit and revise on the fly. It lets me download the latest Supreme Court argument or decision at the same time as millions of others. So these technologies are good, and their features are good. But there is a conflict, and there's a conflict at the bottom, which I think is actually a fundamental one. And so we're living in a world that was built for these earlier time rules. And you can see that pretty easily. And one of the things that struck me about a couple of the conversations here is that what these rules do fundamentally in both copyright and trademark is they ban creativity and then allow it with certain minimal exceptions, right? The creativity that users do, that fans do, is an exception in copyright law. It's the fair use doctrine. It's fair use in trademark law as well, a little less onerous for a couple of reasons. Patent is also a monopoly where you have to have an exception to be able to act. So we've got all of these doctrines that ban everything and then create little exceptions. And we spend a lot of time, and believe me, I spent a lot of time in the last 13 years that I've been at EFF fighting over the size of those little holes and trying to make them fit where people are. But I would submit to you that that maybe it's all backwards. Right? Maybe we need to think, and I think that the right to create, the creator's right that was talked about in the very first panel, is trying to get at the same thing, which is how do we create something that flips things around a little bit? Maybe not completely. This is a thought experiment for folks who are in the panel, but I will tell you, I mean, this is the concern that led my friend Larry Lessig to say "fuck fair use," which he said a couple years ago, which made me cringe at the time, and now I might not use the same profanity, but I think I know where he's coming from. And we see this flip. I think the fact that things are flipped around from the way most people, I think, would like to experience their culture, really clearly in some of the gamer cases, right, where we've moved from a world where with analog games you own them. I owned Monopoly. I could take the little iron and do something else with it, and nobody had anything to say about that, or the shoe, or whatever, to a world in which we license. Everything is licensed now. And this is what was going on in the BNetD case, which I was counsel in, and I have not forgiven the Eighth Circuit for, and several of the other cases that we've been involved with, including, cases involving promo CDs and the several other cases, that in the switch from a world in which everybody is now able to make copies and everybody is able to distribute and everybody is able to display, we've moved into the realm of copyright, and in the realm of copyright everything is forbidden except for the things that you fight to get exceptions for. Now that in and of itself is it might not be that big a deal, because copyright's always been something that was not enforced very much. There was a lot of space, and I think we heard our friend from Warner Brothers talk about a lot of things that are infringing that they just let go. And I think that's true for copyright as well. It's not true for all copyright holders, but it's probably true for most. And from where they sit, since they control everything and everything is subject to exception, they feel like they're being, really magnanimous by letting people do all sorts of things that are on their surface infringing. And we're seeing a little end to that sometimes, and I want to talk a little bit about how that has happened, because we're getting to a world where enforcement, in some ways, is much easier than it used to be. In other ways, is much harder. So I talked about the kind of platform of copyright and the platform of trademark that everybody wandered into when the technology let them be free. And that might have been enough to deal with. But in 1998, Congress passed another law called the Anti-Circumvention Provisions of the Digital Millennium Copyright Act. This is a subset of the Copyright Act. It's 17 U.S.C. Section 1201, for those of you who don't have it memorized like I do, that banned circumventing technological measures and the tools that help people circumvent technological measures. Basically, this allowed copyright holders to put locks on their works and created civil and criminal liability for circumventing those locks. Again, Congress's approach in the context of anti-circumvention was pretty much the same as it was under copyright law, which is everything's banned unless you've got an exception. And the 1201, to its credit, has a couple of exceptions. Reverse engineering is an exception under 1201. Interoperability, for interoperability. Libraries have a little exception for 1201. There are computer security experts have little teeny exceptions into 1201. None of them have ever been used. None of them have ever been useful to anyone because they were drafted so narrowly. So a world in which you ban everything and then you create exceptions, again, you being in all you get to do is fight over the size of the exceptions. And I will say, having handled the very first case involving Section 1201, a case called Universal v. Corley, and had a hand in very many of the cases ever since, those exceptions have been of no use whatsoever to us. And the other thing that 1201 did that was even worse than the copyright landscape that it came into is that it closes the hole for fair use. So if you circumvent something, even though you circumvent it for purposes of making a fair use, you don't have an exception under 1201. You may be completely legal under copyright law, but you don't have an exception under 1201. That was the argument I made in our very first 1201 case, the Universal case, and was rejected by the courts, and then several others since then. Now, 1201 does have another little tiny safety valve, and that is the Copyright Office has a triennial, however you say that, rulemaking where it can carve out tiny little exceptions for anti-circumvention. But importantly, those exceptions don't reach tools. So the copyright and EFF and Professor Tushnet and lots of people have spent a lot of energy over the years trying to carve out little teeny holes in 1201 for anti-circumventions. That's why you can do bidding. That's why you can unlock your phone, or at least you used to, and why you can jailbreak your phone. EFF's work, along with many others, helped create those exceptions. Video, jailbreaking, and unlocking. Unlocking is the ability to use your phone with a different provider. Jailbreaking is to be able to use your smartphone with apps from someplace other than the App Store. And then vids are the people who do fan fiction and other sorts of things using video as opposed to using text. So we were able to get some tiny little exceptions for those things, but we've seen 1201 create all sorts of other problems. We've seen it prevent follow-on innovations. That was what was going on in the BNetD case. My client created a tool that let people play a Blizzard game in a different way than Blizzard wanted them to, and that's why they were sued. That was the case that we lost. Sony versus HOTS is a situation in which Sony put out a PlayStation that let people do all sorts of other things with it, and then decided it didn't like that and locked it all down, and somebody tried to recreate the powers that Sony had just taken away and was sued. So we and 1201 is the tool that's used. That EFF has now just released, I think, the 15-year unintended consequences report. That says 12. I'm not sure that's current for the Digital Millennium Copyright Act. Where we track a lot of the problems that these things have caused. Now, the Digital Millennium Copyright Act did some good things. It did protect intermediaries with safe harbors. That's very, very important. That's why we have YouTube and Craigslist and and eBay and many other intermediaries that people rely on every day. However, it also created a notice and takedown process where you could take down other people's speech with a mere notice. This is the kind of thing that makes people who are First Amendment lawyers like me's head kind of explode, because we have all these doctrines. How many of you guys have studied the doctrine of prior restraint? So prior restraint says that you can't take down somebody else's speech beforehand. You can't prevent somebody from speaking beforehand unless you meet a very, very high standard. In the context of a threat to national security, there must surely directly and immediately be a threat to our nation or its people under the Pentagon Papers case. So if the problem is national security, you have to go to court and get an injunction on a very high standard. If the problem is copyright infringement, you send a notice and it comes down. See a problem there? Because I do. In any event, the notice and takedown provision isn't enough for the content industry, because now they've engaged in a process where they're getting intermediaries themselves to implement a censorship scheme that's even better than the one that Congress gave them. That's called the Six Strikes provisions. Are people familiar with Six Strikes? You should take a look at it if you want to. It's about to be implemented by an ISP near you, if you have a major ISP. and is a process by which people will have consequences with regard to their internet connectivity if they are accused of copyright infringement. And it contains I didn't think 1201 had very good safeguards, and Six Strikes is even worse for this. Oh boy, have I painted a dark picture. But the truth is that I think technology is still winning. There's more innovation happening now than ever before. There's more music being made and shared now than ever before. Those numbers are very clear. I think the same will be true for video and other kinds of things that people are managing to make their way either through this thicket of laws or ignoring this thicket of laws and doing more creativity and more interesting things than any other time, I think, since I've been around. Now, where does EFF fit into all of this? Well, the Electronic Frontier Foundation is a digital civil liberties group. We're based in San Francisco. We currently have about 45 employees, 14 lawyers. And our job is to try to make sure that your constitutional rights make it intact when you go online, come with you intact when you go online, and to protect innovation and fair use and your right to rip, mix, and burn in the digital age. So as I mentioned, we took the first 1201 case to try to create more space in 1201 for fair use. We were not successful. We took the BNet D case. We also weren't successful there. We win a lot of cases, though. We helped get the 1201 exceptions for VIDers and unlockers and jailbreakers. We helped establish that the First Amendment applies fully to the Internet long ago and have defended it in multiple situations since then. We fought bad proposals like SOPA and PIPA that would allow intellectual property claims not just to manipulate what you can publish online, but the very domain name system itself. We've helped protect intermediaries, and we've helped try to grow the copyright safe harbors, or at least give them their fullest protection. And we've helped try to create and develop tools to help people who have been faced with improper takedown notices online, including a part of the Digital Millennium Copyright Act called 512C that lets you sue somebody for making a false copyright claim against you. We have a case that's somewhat famous or infamous at this point, involving a mother named Stephanie Lenz, who videotaped her toddler dancing around the kitchen with a barely audible Prince song, "Let's Go Crazy," in the background. This case has been in litigation for so long now that the little toddler is now, I think, about to start kindergarten, and I may be even older than that, Holden, at this point. But the Universal claimed that her home video was a copyright infringement and had it taken down. And we've used that case to try to ensure that people who are on the back end of improper copyright claims have remedies for them. I will say right now, Congress didn't give us very much in that regard, and we're making the most of it, but we're going to need some help on that. So that's kind of an outline of what we've done so far. Where do we see things going, and where can you guys help? And specifically, of course, I'm talking to the students here. I think the first thing that we need to think about as people who care about the law and how the law interacts with people's lives is, what does it mean to own something digital? Do we even own things that are digital anymore? And should we be able to? Should we be able to own something in the way I owned my Monopoly board, where I could make it about the streets of my hometown? I could play with all sorts of things. I could do all sorts of things with it that were not at all what Parker Brothers wanted or thought that I should do. Do we want to create that kind of space in the digital world? And if so, what does it look like? For those of you who care about international law, there's a huge international dimension to all of this. This is a fight that is not just going on in the U.S. under domestic laws. Right now, the Copyright Office is considering reforming Section 1201, the Anti-Circumvention provisions of the Digital Millennium Copyright Act. And the concern that has been raised is that actually we have trade agreements that wouldn't let us reform the law. Effectively, the United States Trade Representative has made deals that tie Congress's hands about how much freedom it can give us to play with our own stuff. What does it mean for this country when our trade agreements might get in the way of Congress deciding what the laws should be for us. Trademark law. We haven't seen a huge amount of trademark law use, but there have been a few cases. EFF has handled a case involving people who are claiming ownership in the right of urban home in the words urban homesteader to try to knock urban homesteaders off of Facebook. Literally, an urban homesteader is somebody who farms in their own backyard or in a place in an urban landscape. We also represent people who use the term gamer, G-A-Y-M-E-R, to indicate gay gamers, and had somebody get a trademark in that word and trying to invalidate the trademark on the grounds that that's what gay gamers have called themselves long before the trademark owner ever showed up. There's a lot to happen in trademark law right now. Trademark law hasn't really begun to grapple with the new technologies, and I think it's going to be especially important in the context of things like the 3D printers and other things. How do we square all of these intellectual property laws with the First Amendment? And, as you mentioned, I feel very strongly that we seem to have turned off concepts like prior restraint, strict scrutiny, narrow tailoring when a claim that's being made is copyright. We had a big battle in order to preserve people's rights to anonymous speech under the First Amendment standards in the context of a copyright claim. And then the Supreme Court thinks that has said that the fair use doctrine and other doctrines encompass all of the First Amendment in the context of copyright law. I would submit that that's not true, and that we need to think a lot harder about how we're going to balance free speech and copyright and trademark law as we move into the digital age, where all of the rest of us can play with these concepts as well. What do we want to do about private schemes like the Six Strikes Law if intermediaries can be required by terms of contract or the deals that they strike with the content industry to create a very different copyright law for us than the one that Congress has passed? Do we care? Are we going to let contract be used in that way? SOPA's not going away. There's SOPA 2. I'm happy to talk about that in questions if people want to. What do we want to do about things like trying to make sure the next innovations happen? One of the things that EFF is trying to do right now is to create space for open wireless. So you don't need a username and a password to get on the internet. We think this is going to unleash innovation in a whole new way. When people have real-time internet connectivity, you already see a glimpse of this because people have smartphones that tend to be connected everywhere. And the amount of things that you can do when you've got real-time connectivity 24/7 is great. If that included your computer as well, I think we'd see even more. And it's within our grasp. Open wireless there are wireless networks everywhere. The problems are contractual and legal, not technical for this. That's just a smattering of some of the questions that we have. There are a zillion more. So I want to urge you to think hard about, if you're interested in intellectual property law, to think about the whole spectrum of intellectual property law, not just the side on the side of the rights holders, but the side on the rest of us, because both sides need to be well represented. One already is, and the other one has me and a ragtag team of other people. So our team needs you. So to me, the most fun and the most interesting stuff happens in the questions. I'm happy to talk more, but let's open it up and see if anybody has any questions. I'm happy to talk about anything EFF does. The one caveat is that I am not a patent attorney, so I can only talk in vague generalities about patents and send you to my colleague Julie Samuels or Daniel Nazer to talk in more specifics about that. Oh my goodness.
What's your view on the copyleft movement?
On copyleft?
Yeah.
On the open source licenses and things like that?
Yes, or commons. Or do you think that getting rid of property rights or any sort of intellectual property rights will solve all the issues now?
Well, I think they're really great experiments, right? There's both the open source licenses, and Creative Commons, which is not quite open source in the same way, although they all play together now a little better than they used to, are really great ways to experiment at the world. I mean, Congress and they're both trying to work within the current system to create more space. So I think they're both really good and interesting endeavors. I think the open source movement has demonstrated the power of letting a whole lot of people in, and the weaknesses of having one company or one corporation control the development of software, right? The Apache server is a much better server than anything that was developed inside the houses. It's an open source product. The explosion of innovation that we've seen when we let people collaborate and develop things kind of in a more open and democratic way. I just don't think there's any argument against it at this point. Now, I'm not saying it's the only model. I think people should be able to have different models, and we'll see, let the best one win. But I think open source is great. Creative Commons is also something I think is important. I don't think Creative Commons has anything to do with weakening. Neither of these have anything to do with weakening intellectual property rights. If you want to weaken, I'm going to leave EFF someday, and I'm going to start the Foundation Against Bad Metaphors. And it's going to start with intellectual property because it takes you to a whole different way of thinking about digital things than actually is really, I think, right. And as lawyers, I'm sure some of you are in law school, it was a revelation to me to go to law school to realize that real property didn't actually mean what I thought it meant, right? Easements and limitations and all of that, right? So real property doesn't mean what most people think it means. And intellectual property as a metaphor is fairly recent, and I don't think it's very useful. I think it takes you to places that are not very complicated. But Creative Commons is purely within it, right? Creative Commons says, as an author or a creator, you get the right not to pick all of the exclusive rights, but to pick the ones you want and pick and choose. I think it's actually empowering, and it's completely empowering within the current copyright structure. And so I think that's also great. I think I'm a big fan of letting a lot of experiments work, and then letting the world play out which one of these are going to be successful. I think both Creative Commons and open source are demonstrations of good experiments, and I think open source is older than EFF. I shouldn't really call it an experiment anymore, but a good way to kind of propagate different ways of thinking about how do you get to the best place. And the best place, of course, is to have the best technology, the coolest stuff, and the most innovation. And so I think both of them are successful in that regard. I don't think they pose any more threat to intellectual property schemes than gay marriage poses to straight marriage, but maybe that just betrays my San Francisco roots.
It would be sacrilege to let an academic legal conference go by without mentioning privacy. Do you worry at all about new methods of surveillance being used as a way of ensuring copyright enforcement?
Yes.
And people signing away all those rights in end-user license agreements?
Yes, I think that, again, I come into this world as a First Amendment lawyer, and I would say that the bulk of my time is spent on government surveillance technologies. We just got national security letters declared unconstitutional a couple weeks ago. So yes, I worry about intellectual property as a basis for trying to undermine things. It is one of the big things that worries me about six strikes. Things like deep packet inspection and other sorts of techniques that are increasingly being used by ISPs to do things like traffic management. There's a huge pressure on them to use those tools to try to protect against copyright infringement. I think that the risk of this is it's not even just a risk. It's just true. We've lost a lot of our privacy at the altar of intellectual property. And I think it may get worse before it gets better. And it is a little strange that, I spend a lot of my day fighting the national security apparatus of the United States and the Department of Justice and talking with, generals and stuff about how much privacy people need in a world in which there are dangers and they want to try to protect us against terrorists. And then have those exact same arguments being made about intellectual property, which I would submit to you isn't as important a value in our country as stopping terrorists. And I'll tell you that a lot of the times I find the national security guys to be a little more reasonable. So yeah, I think it's an important problem, and it's one of the reasons that EFF cares. EFF, I don't really care. It's not that I don't care. Intellectual property isn't what gets me up in the morning. What gets me up in the morning is the promise of the internet and a free and open internet and what we can build and do together with this internet. And I care about intellectual property because I see it as having been and continuing to be sometimes too big an obstacle to the kinds of things that we need to have to move our innovation forward. Privacy is another thing that I get up and worry about in terms of making sure that as people move online, their right to privacy comes online with them.
You sound very optimistic in the big battle, and I'm thinking of people like Lessig, and frankly, some of us who've been looking at this for the last 30 so years since the last version, the major redraft of the copyright law. And it's a very pessimistic story. And, people like Lessig and others have said, can't win. I mean, or it's not likely that one's going to win. And the pretext that's being used what's been used increasingly for the last decade or so, well, we have to change our law to satisfy the international storyline so that we don't find ourselves at a disadvantage. So I know why you get up in the morning, and I understand the good battle, and I am with you. But is there any reason for optimism at all, and/or is there a tactic that we can begin to develop that gives us reason for optimism?
Well, I think I'm glad you think I'm optimistic. I thought this was an incredibly depressing presentation. As I was going through it, I realized how sad it was. And it's true that my friend and hero Larry Lessig decided that until we could change Congress, we couldn't change IP laws, and that's why one of the reasons why he left to change Congress and begin to try to fix those things. To a certain extent, the fact that Congress is broken affects all of us in all sorts of other areas, and internet regulation and lack thereof is only one of the areas. I mean, I think a couple things make me optimistic. One is, of course, the SOPA PIPA fight. I think that we had been told that this was a done deal. We were told this was a done deal when it was called COICA, and it was called something else even before that. We were able to rally enough support to get things turned around, and that's the first. We've had all sorts of little victories stopping bad before, but that was, I think, the biggest and the most high profile, and it certainly resulted in a sense in Washington, D.C. that maybe they ought to listen a little more to us. I wouldn't say it's a lot yet. The other thing I think of is that I think that, if you look in the world, we may not be winning in terms of the law, but we're winning in terms of the technology. People are making fan fiction. People are building 3D printers. People are modding their games. People are doing all sorts of great, cool, fantastic things. Some of them, maybe not entirely legally, and I really want to fight for that. I don't think you should have to break the law in order to be creative. But that thing's been unleashed, and people are doing all sorts of cool things. So I guess I kind of think that at the end of the day, it depends on what you think of as winning. But if winning is that there's more music being created now than there was when Napster was introduced, we're winning. I think we're seeing that in movies. Frankly, in movies, it's hard to argue that they've got a problem, given that they keep breaking their financial. Every year is a record year in the movie industry, which I think is great. I want the movie industry to thrive. I love movies. So I think that while the policy fights might not be going so well, the practical world that we're living in, we're winning, and we're going to continue to. Policy often has to catch up, and sometimes doesn't catch up at all. But I do think that there are. There's more stuff available to more people that they can play with and do stuff with now than there's ever been, and I think that's going to continue. So I guess that's where my optimism comes from. And, you know, I mean, I guess, you know, I think when I think about the intellectual property battles that we've been fighting and the way things go, I mean, the industry's moved a long way. I think, you know, when we started, the idea that there would be 4 or 5 different streaming services where you could get pretty much any music you wanted at a reasonable price seemed crazy. People thought we were crazy for even suggesting that that was a possibility because, you know, no one would ever make music if they couldn't control it. You know, they were thinking about putting technological protection measures on CDs when I started, and there was a couple of fights that we were involved in that, and that got dropped. You know, there's lots of factors. I wouldn't say, again, I think EFF is kind of a small player in a lot of these stories, if we're a player at all in them. But I think people are getting access to stuff. More stuff's being made. People are doing innovative things with them. And then my job is just to try to make that better and safer and, you know, less likely to get taken down.
Does EFF have a position on counterfeit goods? Does it share the viewpoint that it's about a $600 billion industry, and do they participate in any of the activities to reduce those?
I don't have any idea about the numbers. I think counterfeit goods is a problem. It's not something that, I mean, if you're thinking about counterfeit goods as in, you know, knockoff purses that come in and things like that, I mean, we tend to have expertise more on stuff having to do with digital technologies and the online world than the offline world. So we don't tend to participate in those, but I don't participate in a lot of battles that happen in the offline world. I don't. You know, I care a lot about computer trespass, but I don't get involved in the fights about physical trespass either. So I think counterfeiting is just outside of, at least as I think you've defined it, the kind of traditional counterfeiting is kind of just outside the scope of what we know about and what we participate in. I'm certainly not, you know, we don't endorse counterfeiting.
I guess the state of trademark law is undoubtedly kind of lagging behind copyright and patent, and I'm just kind of wondering what implications you think that has in the internet realm and also in terms of fostering innovation and creativity.
Well, we're beginning to see hints of it. Thank you for the question. I think that trademark law has been on our radar as something that we had to, you know, kind of ramp up about and pay attention to for probably the last 4 or 5 years. And the Gamer case and the urban homesteading case that we've taken on are kind of our first forays into some of that. Those are both cases where we're trying to get the trademark, go through the trademark office's internal process to get the trademark, I don't know the exact technical word, but declared canceled. Thank you. You can tell I'm not really an IP lawyer. Prior restraint rolls off the tongue so much more easily. But I think it's an issue, and one of the things about trademark, I mean, trademark law is better and worse than copyright laws in some ways. I mean, first of all, there's a really clear, you know, not commercial use area for trademark laws, and so that gives it kind of a smaller scope than the way copyright law has been interpreted. But there isn't a safe harbor for intermediaries, and so in the Gamer case and the urban homesteader case, the intermediary involved. In the Gamer case, it was Reddit. In the urban homesteader case, it was Facebook. And they took stuff down, right? Because they don't have, you know, they don't have a safe harbor in the way that they do under copyright law. So there's ways in which trademark law is worse and kind of more worrisome. And there's ways in which it's not quite as worrisome. But I think especially, you know, we're seeing trade dress and trademark and those kinds of things become more in vogue as claims that can be made, and so I think it's a coming problem. I think somebody who wanted to pay attention to what to do to make trademark law better and maybe avoid some of the pitfalls that we've gone through trying to make copyright law fit the digital age, it'd be a really right place for thinking right now.
So first, thank you for this wonderful conversation. I wanted to ask, you mentioned a few times that in your view, technology is winning, and in fact, we are winning because look, there's more there's more music out there, there's more, perhaps even just conversation happening. Why is more necessarily better? Why is more winning? And it might be very intuitive to you, but I struggle with it quite a bit.
Well, I think in copyright law, the Constitution says that the reason we create a statutory monopoly in the works is to incentivize the creation of creative works for all the rest of us to enjoy. So I just took that from Jefferson. I think that that's right. Actually, I think that if government's going to get involved in these areas and create monopolies, which those folks who are of a conservative bent, I always find it funny that that this grand statutory monopoly is something that doesn't get a little more scrutiny from the people who otherwise don't really like regulations that create artificial monopolies. And I'd love to see more scholarship and thinking about that. But so I think that if the government's going to get involved in the area of copyright, it is to try to create more works for the rest of us to enjoy. Trademark law has a whole different goal, right? Trademark law is to me, is about avoiding consumer confusion, and that's not really about more. That's kind of a more it's a different goal. In patents, I think the patent thing is about encouraging. I'm trying to remember the patent clause, but I think that's also trying to encourage more. So, you could ask what government's role ought to be here, but it's clear if you're following the Constitution that the government's role is to try to foster the creation of works for the rest of us to enjoy. I'm not sure Jefferson wrote that piece, but seemed a safe bet.
Can you talk a bit about SOPA 2 and how it's different from the SOPA last January, and what EFF is doing to sort of halt it before it can implement it?
Well, there isn't really a SOPA 2 yet, so I should be clear. It's the thing that we all worry about. I think that, and there was a statement by, oh my goodness, the former senator from Connecticut, who's now Chris Dodd, saying, they were done with that. I think that those of us who have been watching the Registrar of Copyrights gave a big speech recently, where she talked about the need to kind of reform copyright. We're coming up on 30 more years. Apparently every 30 years we have to revise copyright. I'm not sure, I didn't see that in the Constitution, but it appears to be taken as an article of faith by people. And we're coming up on that because it takes 10 years to do it. So I think that there's a lot of concern that buried within her statements are the kind of seeds of what is going to try to come back and be, and when I talk about SOPA and PIPA, the thing that I think is most important is that we don't let the inner workings of the internet be manipulated and thereby people censored through intellectual property claims. That's a bridge too far. What I often say is, if you are accused of making harassing phone calls, the phone company doesn't have anything to say about whether you have continuing phone service, right? Similarly, other kinds of bad behaviors using other technologies doesn't make the role of the technology creator to be your police.
What do you think about the idea of a copyright small claims court, and what type of effect do you think it would have?
I'm actually not sure. I'll tell you I haven't thought about this thoroughly, so this is just off the top of my head. I worry that, one of the reasons that people have been able to enjoy a lot of things that would otherwise be called infringement is because the cost of enforcement is so high. And I think that served as a very good governor on copyright holders to make sure that they go after the things that are actually hurting them and not the things that are just annoying them or that are taking their work and using it in a way they don't like. I mean, we don't have a moral rights framework here in the United States, so you can take somebody's work and do something completely different with it than what they really wanted you to, and we let that happen and we celebrate that. So I worry that a small claims court could end up being really over-enforcement of intellectual property. I think making people have to come to, especially in the context of copyright, because if we're going to do a small claims for copyright, then we should get rid of statutory damages. Right? You should have to prove your damages, and this is one where I agree with my friend at Warner Brothers. It shouldn't be involving injunctions. So I'm not sure that solves any problem, and I think it creates others. I mean, lots of people floated that ideas, but that's kind of my basic thought about it. I mean, I might be willing to make that trade. You can have a small claims court if we get rid of statutory damages, and you have to prove that you were hurt the same way if there's infringement as you do if somebody punches you in the nose. Well, thank you very, very much for letting me come and ramble a little bit in front of you about various IP topics. I should be really clear. I don't want to get rid of intellectual property. I really want it to just stay within some reasonable moorings and not serve as a First Amendment problem and a privacy problem and all of those other things. I think there's a way in which we can live harmoniously together. Some of my friends on these things have kind of given up and said, let's just get rid of the whole idea. And that's not really where I am. It's certainly not where EFF is. But we do feel like the balance has slid too far, and that we need to work, at least in the maybe not in practice, but in the law, and we need to work to bring it back a little bit. And if you want to come help us do that, please think about coming and doing an internship with us or volunteering with us if you're in private practice. We have a large network of cooperating attorneys who help us in our cases. So even if you can't make your way to San Francisco, keep us in mind as folks who could certainly use and would be interested in having pro bono or volunteer help. So thank you.